further hearing in the appeal Star Energy against Bocardo SA.
Yes, Mr. Gaunt.
Good morning, my lords. My lords, I had reached section 15 of my submissions
Yes.
to deal with the Pipelines Act. This arises because in paragraphs 158 to 169 of their printed case, Starr argued that they could have acquired the necessary right under the Pipelines Act 1962. Now, this was a point which was not taken at trial at all, nor was it the subject of the notice of appeal, nor has permission ever been given to take it on appeal.
Could you give me the paragraph number again? I'm sorry.
Paragraph 158 is where it starts, 158 to 169
Yes.
of the respondent's case. Of course, we've seen that the debate was conducted on the basis that there were rights under the 1934 and 1966 Acts, but they say, in addition to those, they could have gone under the 1962 Act, the Pipelines Act. Now, the point wasn't taken at trial, not the subject of the notice of appeal. Permission to raise it has never in fact been given. It was debated de bene esse in front of the Court of Appeal, but the Court of Appeal did not see that it was necessary to deal with it. It simply said they didn't need to deal with it. The measure of what would have been the measure of compensation under the 1962 Act was not investigated at trial. The valuers weren't asked what effect it would have had on the hypothetical negotiation. That being so, in my submission, it's a point which should not be permitted to be raised on appeal. However, in case your lordships disagree with that and think that the point should be investigated, our submission is that the Pipelines Act is to do with the conveyance, as it were, across country of oil and other substances, and not to do with oil wells. Now, there is, as your lordships have seen, a distinction in the Acts between what I call oil wells and oil pipes. Starting with the 1934 Act, which your lordships have in volume 2 at tab 14. Section 3, of course, is the one that enables the operator to apply for ancillary rights, and it is section 3.1b which lists a number of ancillary rights that they can apply for, and those include various rights to enter on land and sink boreholes for the purpose of searching for and getting petroleum. That's obviously the oil well. And subsequently, it talks about the construction of such other works as may be required for the purpose of searching and boring for and getting the oil well, carrying away, that would be a pipeline, storing, treating, and converting petroleum. One can see a similar distinction drawn in the wording in the 1923 Act, was incorporated by the 1934 Act. The 1923 Act is in volume 1 at tab 10. Section 3.1 gives examples of ancillary rights. This, of course, applies to minerals other than oil, as well as oil. And 2b talks of a right of airway, shaftway, surface or underground wayleave, or other right for the purpose of access to, so that's getting at the mineral, or conveyance of minerals. That's taking the minerals away. or the ventilation or drainage of the mines. Now, while your lordships have section 3.2b before you, I wonder if you could just note this. Section 57 of the Pipelines Act, the 1962 Act, amended this section 3.1b by adding the words after conveyance in brackets. They added the words otherwise than by means of a pipe. So it read, other right for the purpose of access to or conveyance otherwise than by means of a pipe of minerals.
So which section of the 1962 Act?
Section 57.
57.
I'm afraid if your lordships look at it in the bundle,
I see just dots.
it isn't there.
Yes.
It's gone because it was subsequently repealed. But so this is why I'm telling you, lordships, that you won't find it by reading the Act as printed in the bundle.
So otherwise than by means of a pipe.
Otherwise than by means of a pipe. The point being that the Pipelines Act, when it came in 1962, dealt with conveyance by means of a pipe. So the Pipelines Act supplanted the previous provision as far as it related to pipes in the 1923 Act.
But without that, just to try to think, I mean, let's assume that minerals are something like coal or shale or whatever it is. It could be, you might need a right of access to trundle a truck along a rail or something like that.
Yes, yes. Absolutely. Or to trundle a truck through an underground passage in a coal mine full of coal.
Yes.
So certainly there would be other conveyance situations. And one would also obviously need to take the goods away from the pit head by one means or another, by a railway line perhaps, or by an overhead conveyor belt or something like that. So there's the distinction between access to the minerals, getting at the minerals on the one hand, and moving them away from the pit head on the other. So when we come to the Pipelines Act, which is in Bundle 2, at tab 15, certain rights are conferred by sections 11 and 12 for pipeline construction. I'm not going to take your lordship to the subject matter of those sections. I just draw attention to them. They are the sections which enable a person who wants to install a pipeline to acquire land for the purpose, or to acquire rights for the purpose. There are two different procedures, a rights order and a land order. But the important thing is the definition of pipeline. And that's in section 65.
What page is that?
It's page 63 of the Act as printed. Section 65. In this Act, pipeline, except where the context otherwise requires, means a pipe, together with any apparatus and works associated therewith, or system of pipes, together with any apparatus and works associated therewith, for the conveyance of anything other than air, water, water vapour, or steam, not being various accepted things. So it has to be a pipe for the conveyance of anything. Now, my rather simple submission is that the wells themselves are constructed to get access to the minerals, they are bored in order to search for and get the minerals, to use the wording of the 1934 Act. To search for, bore for, get the minerals. They're not there for conveying the minerals away. That would be by way of a pipeline to which the Pipelines Act would apply.
Does it, what you're saying, conveying it away, I'm looking at the exclusion in little b, just as an example, of something that they thought might otherwise be covered, and that's system of pipes for heating or cooling in domestic purposes.
Yes,
It's water just going round and round in a circle,
yes.
not actually travelling, but just fulfilling a function.
Yes.
So conveyance just simply means moving, doesn't it, from point A to point B? And I quite see the point that when you think of it normally, it would be conveying over quite some distance from the well to the refinery or whatever. Yes. But in a sense, you could say it's being conveyed from the apex to the wellhead.
Yes.
Because it's been brought up by means of a pipe.
Well, my lords, that's exactly what my learned friend does say. And I say that when one looks at the 1934 Act, one can see that what is happening here between the apex and the wellhead is the pipe is there in the first place to search for the oil, and in the second place to get the oil. And it isn't there for the conveyance of oil. It isn't what the Pipelines Act is really about. The Pipelines Act is really about acquiring a different sort of pipeline.
Matter of interest, what do you actually do with this oil when you get it to the wellhead?
What do you do with it?
What do you do with it?
I think we carried it away in tankers. When I say we, I mean Star Energy, of course.
Likewise, yeah.
I think the evidence was that they tankered it.
I see. Well, I mean, what happens if you get it vertically as opposed to diagonally? Do they still say that's a pipe?
Well, I think they
would.
would.
Yeah.
I think they would.
I mean,
say
logically,
that
they would.
That was a pipeline within the Pipelines Act, even if it was vertical. But of course, they wouldn't need any rights under the Pipelines Act in that case, because it would be in their own land.
Okay.
And what's the significance of all this?
Look, the significance, I think the way it's put against me is that the compulsory purchase principles and the Land Compensation Act 1961 is incorporated in the Pipelines Act.
Which section does that?
Well, I think we can see 12, section 12. Does it look like that?
Section 12 is the rights, and I think it's one of the
Section 11
schedules.
is the order.
It's one of the schedules that deals that says that. I'm sorry, no, section 11. I see.
Yes.
Section 11.4.
Yeah.
Provisions of the third schedule of this Act shall apply to a compulsory purchase order for the purpose of rendering it effectual and modifying the Land Compensation Act 1961 in relation to the assessment of compensation. So as far as Section 11 is concerned, it's the Land Compensation Act as modified by the third schedule. And I think there is a similar provision in regard to Section 12. So what is said against me is that the rights could have been acquired more cheaply under the Compulsory Purchase Code than they could have been acquired under the 1934 and 1936 Acts. That wouldn't have
There's a sort of point good type of provision in Schedule 3, isn't there, on page 84?
What page?
Or no scheme provision.
no scheme provision.
Where's that?
Page 84 of 85.
Yes. Schedule 3, paragraph
Paragraph 3.
3.
So that's the significance of it. Of course, on no view could this be relied upon to enable the wells to be constructed in the first place, because the process of searching for and boring for the oil in the first place would not have been conveyance on any possible view. So, in order not to commit an initial trespass, it would certainly have been necessary to go under the 34 and 66 Acts. Now, your Lordship should know that in the BP and Ryder case, before the judgment of Mr. Justice Gibson, there was a hearing before Mr. Justice Warner. There is the judgment is in the bundle. And that arose because the bundle of rights being sought in connection with Wych Farm included pipelines. And the Secretary of State was unsure as to whether there was jurisdiction to deal with pipelines under the 1934 and 1966 Acts. And there was effectively a preliminary issue as to whether those acts did cover pipelines. And it was held by Mr. Justice Warner that they did. And so the court did have jurisdiction to deal with all the various bundles of rights which BP required in connection with the Wych Farm oil field, which was very convenient because otherwise they'd have had to deal with one lot under the 34 Act and one lot under the 1962 Act. So it's right I should let your Lordships know that. But it doesn't affect my submission here, which is that what we have here are oil wells, and oil wells are not covered, in my submission, by the 1962 Pipelines Act.
I'm not, haven't had time really, obviously, to go through all of this, but Section 1 is talking about cross-country pipelines.
Yes.
And one's familiar with those things, taking oil or gas for long distances, but and you would say this isn't a cross-country pipeline.
Well, certainly not
but that doesn't answer the whole problem. And then Section 5 is talking about planning permission. And there's a section dealing, I think, with the design of these for securing the pipe. Section 9, securing it so constructed as to reduce the necessity for construction of others, and so on and so forth. And that's a construction of a pipeline to be designed for the conveyance of a thing for a particular class, and so on. Would it be right to imagine that the initial boring, the pipeline used initially for boring and searching, is the same pipeline that is used when oil or gas is actually discovered, and it's just simply the same pipeline? You don't have to, as it were, take up the boring thing and put in a new one. Do you know enough about it to be able to answer that question?
My Lord, I don't think I'm technically equipped to answer that question. You certainly don't take out what you've put in. I think you may put a different lining down the tube. The installation is referred to technically as tubing and casing, and it may be that the original well has to have something else put down it when you actually start production. I know, for example, that PW5 was extended. The original exploration well was extended before they started production. That doesn't answer your Lordship's question, I appreciate, but I'm afraid technically I don't know. I mean, if there's anybody here who can give me instructions on that, I'll take instructions. But and it may be that on my learned friend's side there are people who know much more about this than I do.
I mean, can you think of any sort of coherent policy reason why, they would have a different approach to compensation for pipes for carrying away the stuff than for, so to speak, getting it to the wellhead in the first place?
Well, my Lord, no. I tried to answer
we
this.
perhaps went through this yesterday. All you say is that there's an accident of history in drafting. That's the position we've arrived at.
My Lord, whether it was an accident or not.
Well, but if I'm trying to ask, what I want from you is a reason why it might not be an accident.
Yes. Well, the best I could do yesterday, and I think the best I can do today, is to say that the 1923 Act was dealing with lots of different minerals, not just oil, indeed not principally oil. Then along comes the 1934 Act, which relates to oil and incorporates the provision of the earlier Act. And then comes the 1966 Act and consolidates the 1923 Act. And because the 23 and 66 Acts are dealing with quite a lot of rights, rights to acquire the surface, rights to cause subsidence, rights to drill, rights to quarry, rights to mine. It may have been thought, for reasons that I'm afraid are quite obscure to me, that the compensation code in the 1919 Act and the 1961 Act, and that series of valuation rules that one finds in those codes, and all the assumptions and disregards that go with them, simply weren't applicable to this subject matter. Now, why that would have been thought, I don't know. I can't look into the mind.
Well, one possible distinction, it's probably too simple a distinction, is that there is, as you were emphasising yesterday, oil under your client's land, and there always has been.
Yes.
There isn't any oil before you put a pipeline across two counties to take it from a terminal to a central distribution depot. It is more appropriate. It is the scheme of having a pipeline that brings the possibility there for the first time. Whereas, as you were emphasising yesterday, the petroleum's been under your land forever.
Yes, but I can certainly see why the compulsory purchase code would be applied to the pipeline that goes across two counties. I mean, land is acquired all along the line. People's fields are dug up. There is injurious affection. There may be the presence of the pipeline may inhibit future development and cause loss of value and that sort of thing. So one can see why the code would work for a cross-country pipeline. It may well be that the compulsory purchase codes are really too detailed and too complicated to deal, simply inapplicable to the situation which one gets with mining, where the activity is really a rather different activity. It's not taking people's land or interfering with people's land across a distance or for the purpose of a very large scheme. It's simply directed to the various mining operations which the Act permits. And we're talking about ancillary rights.
Can I just take you up on the point that Lord Walker makes? I mean, certainly you take that point, that there is the oil all along, but as I understand it, the way you invoke that point is even assuming that the compulsory purchase code of compensation does apply, this is a pre-existing key value in the land, which even under the sort of point Gord disregard, you wouldn't disregard. I mean, I thought that was the point.
That is indeed my point, my lord.
Yeah.
You're absolutely right.
So that's rather a different way of putting that point than my lord was suggesting. You may have available both ways of putting it.
Yes.
Am I right? I mean, am I right? I don't want to put cross purposes.
Yes. When I used the expression the compensation code,
Yeah.
I was really referring to the 5 rules which one presently finds in the Land Compensation Act 1961 in section 5. Coexisting with that is the point good principle, which your lordships have held does coexist. It hasn't been consolidated, as it were, into the statute, and it still applies. The compulsory purchase code, in the sense that I used it, certainly doesn't apply. It certainly doesn't apply. It isn't incorporated. It isn't referred to. But the question is, does a point good type principle, the no scheme principle, if you like, to use a shorthand, does that have any application? And I say, well, no, it doesn't. You don't need it. But if it does, then it doesn't have any effect here because the oil is pre-existent and the value of the oil is pre-existent and the value that the presence of the oil gives to my land and my bargaining position is pre-existent. And that was the your Lordship was, as it were, playing that argument back to me, and I was agreeing that your Lordship had my point.
Yes.
My Lord Walker, I'm sorry, I may have mistaken the point that you were putting.
Well, I think I was groping towards the same point. I don't think there's all that much between us, but anyway, let's leave it there.
I'm relieved to hear it.
It would have been very difficult to create a different regime for pipelines under the Pipelines Act from that which applies to roads, for example,
Yes.
trunk roads, highways, all the other
Yes.
things, railways, canals, all the traditional things where things go across the
Yes.
surface of people's land over a distance.
Yes, it would have been surprising if they'd seen the need to do that. And as I've pointed out in our printed case, when you have things like gas pipes and electricity cables and sewers and so on, they all have codes which, telecommunications for that matter, they all have codes which do, to a large extent, incorporate, sometimes with considerable modifications, the compulsory purchase principles and the compulsory purchase acts.
And they're all bringing to the land something that wasn't there before, except possibly the fact that the land is suitable in terms of gradient or substratum or whatever it is for the laying of whatever it is they want to lay.
Yes.
But it doesn't really go further than that, I think,
No,
does it?
No. My Lord, my point is essentially a very short one. It is that when you drill an oil well, the Pipelines Act doesn't permit you to do it. And the act which permits you to drill an oil well and get the oil is or was the 1934 Act, with the ancillary rights available under the 1966 Act.
I mean, does the 1998 Act make any reference to the Pipelines Act?
It doesn't make any reference to the Pipelines Act, as far as I'm aware, no.
No.
Any more than does the 1966 Act. Right?
So this will be a different application, postulated application being made by Star, would it?
Yes, yes, a quite different procedure.
And until it was made, on their argument, I suppose the position would be they wouldn't be entitled to convey anything.
No.
That seemed to
No,
follow.
I mean, their argument has to be that the...
So would they need two applications, one under the other Act and another under this Act?
Yes, what is said against me, I think, is this, that when one is imagining this negotiation that one imagines as an aid to deciding on the measure of damage for trespass, you have to imagine that it's conducted against the background not only of the 1934 and 1966 Acts, but also the background of the 1992 Act. And so that in the negotiation, it is said, Star could have, if this negotiation had ever taken place, said, but we can go under the 1992 Act.
62 Act. 62 Act. Is it not?
1962 Act, yes, of course. The 1962 Act, yeah, Lordship's right. We could go under the 1962 Act, and if we did that, we could get these rights more cheaply.
Yeah, but forget about the negotiation. Supposing they said to themselves, we don't want to do any trespassing.
Yeah.
We'd like to go under the relevant statute and have the compensation assessed under the statute.
Yeah.
What would they then do? Would they have to make two applications, one under one Act and one under the other?
No, they wouldn't actually. But they could make one application under the 1934 Act. As a result of Mr. Justice Warner's decision, which was that they could get...
Well, they could, but could they also have made one because they thought they'd get it cheaper under the 62 Act?
No, I say they couldn't, because the 62 Act, whatever it does not give them the right to bore a well, either an exploratory well or an extraction well. the act that gives them that right is the 1934 Act and their petroleum licence.
And that's because initially, when that work is being done, nothing is being conveyed at all, except possibly, I suppose, in
That's
the
right.
reverse direction, mud
Nothing-
or whatever it is you
that-
put in to lubricate the process.
That is searching, boring and getting,
Yes.
which is the wording of the 1934 Act in connection with ancillary rights.
Well, no, but couldn't they get that, and then having successfully accessed this petroleum oil, couldn't they then say, right, now we're going to make a fresh application, because now we've got it, we've accessed it, now what we want to do is take it away.
Well, I think that's what my learned friend says.
Yeah.
But I say that is not conveyance, that is getting oil.
Well, now we're back to the same pipe point. I mean,
Well, it is the same pipe, yes.
it is the same
But
pipe.
there's also-
One that
I
you'd
mean-
have had to put in the first place, would you?
Yes, I mean, when you bore for the oil, you put a pipe down, you find the oil.
Yes.
Now, I said to my Lord Hope a moment ago, I don't know whether you put something else down the pipe as well later on when you start to extract the oil. I simply don't know. But you certainly don't take out the pipe you've put down to find the oil. You leave that there and you go on from there.
But, I mean, if things were handled in what you would suggest is the correct way, before any of this was done at all, there would be a negotiation
Yes.
for a way leave to allow you to put down the pipe to search, to bore and search.
Yes.
And the negotiation really would be over then. Would you need any further negotiation because it would be assumed you'd be getting oil out, or does one envisage a fresh
no, I mean-
negotiation because you actually found oil and now you could put a price on the thing?
What one would expect to find is that the parties did a deal which encompassed not only the right to put the well down, but also the right to use it. And the sort of deal that we have been envisaging is a deal which would involve one party agreeing by reference to a formula to pay for the oil according to how much oil was obtained and what it was worth, which seems a fair way of doing it. And the valuers agreed that was a fair way of doing it. And that is the deal that we hypothesised, not a deal which was actually done, but a deal that certainly could have been done at the outset. And we could have said, you can't come in at all unless you do a deal, apart from the Act, of course. So, my Lord, that's what I say about the Pipelines Act, unless I can elaborate that at all.
And do we need more of the Act than we've actually got?
Rather
What is the incarnation of the Act that we're looking at for this purpose?
Well, it's a heavily redacted one, by the look of things.
No, but in theory, in principle, which Act are we looking at? The original one, or what we've got is the latest version of the 1962 Act, have we, in the budget?
Well, no,
Yeah.
I think you've got a redacted version as well, because
Well, we've certainly got amendments up to 2008,
I'm sorry, I need to look at it.
2009.
Well, it may not matter, but perhaps we could have a copy of the Pipelines Act in the form in which it would be relevant if it were relevant.
Yes, yes, that's obviously the right thing to have. Right, well, we'll check on that for your lordships. I mean, it does look as though we have provided the Act with only those sections which were thought to be of relevance. And perhaps your lordships would like to have a copy of the full Act, so you can see the whole context.
As it was at the date of the hypothetical.
As it was at the relevant
Exactly.
time in the early 90s, yes.
Well, thank you very much. Does this take us then to point 16?
It does. Now, my Lord, for the purpose of this, your lordships need to be reminded of the respondent's case of paragraphs 193 to 197. Now, this section assumes that I'm right as a matter of principle and the Court of Appeal were wrong as a matter of principle. And we are entitled to substantial damages and not the, in effect, nominal damages which we were given. But what is being said here is that the basis on which the judge approached the matter was fundamentally misconceived, and the basis upon which my valuer, Mr. Crawford, approached the matter was in certain respects misconceived. And the first criticism that's made is as to the date of the hypothetical negotiation. And what is said is the judge assumed that the hypothetical negotiation was taking place in 1994, at which date the wells had been drilled. And so there was no question really of putting them somewhere else. And if the negotiation had taken place then, and Starr had said to Bocardo, oh, well, if you won't give us a right, we'll drill somewhere else, Bocardo would just have laughed and said, of course you won't, you've just spent £1 million each on drilling these wells, don't be silly. It is absolutely correct to say that is a factor which the judge did take into account. Now, why did it matter? It mattered because in the middle of the evidence, the oil expert for Starr produced a supplementary report. And he produced a supplementary report, as I told you in opening yesterday, showing an alternative target. And the alternative target lay adjacent to the boundary of Bocardo's land to the north, approximately 500 or 600 yards to the north of the Coney Hill wellhead. But the important thing to appreciate is that it was not on Starr's land. It was on the land of an adjoining landowner.
Bocardo's land?
It was not on Bocardo. Well, no, it was not on Starr's land.
Starr's land, right.
It's not on
I
Starr's
see,
land.
sorry, beg your pardon, yes.
It was not
Yes.
a vertical shaft
Yes.
on Starr's land. It was another deviated well running north along the boundary of Bocardo's land. So in order to threaten Bocardo with this alternative location in the negotiations, it would have been necessary for Starr to take into account the fact that if they didn't deal with Bocardo, they would nevertheless have to deal with Farmer Brown or whoever it was who owned the other land. And our case was, well, even if the oil wells are treated as not being there, it doesn't make any difference because you'd have to pay Farmer Brown and you'd rather pay Bocardo because Bocardo have the optimal location. Now, the learned submissions at this point proceed on the basis, as is clear from paragraph 195, that the pipes were drilled vertically. But with respect, that's a misapprehension. The alternative target was not vertically underneath the Coney Hill wellhead. It was, as I said, another deviated well running to the north. And so it would have required land acquisition. It would also have lost a significant amount of oil because it was not the best place. It was not the apex of the field. Now, having said that, I'm afraid I need to take your lordships on a little bit of a excavation of the parties' positions. Our case, when we opened it, was that 1990 was an appropriate date to take, because that is when the first well went into production, and it was before either of the other wells were drilled. And Mr. Crawford's evidence was all addressed to the date 1990. It was not addressed to 1994. However, Starr's position, both when they opened the case, in their oral opening, and when they closed their case, was that 1994 was the right date. The reason they took that date was that that was when the defendant, Star Energy UK Onshore Limited, became the licensee and the operator, and therefore it was when their trespass began. And Star regarded that as the right date to take. It was not, however, the date on which our evidence had been prepared. But we accepted that because we couldn't see that it did us any harm. And so the case proceeded on the basis that the right date was 1994. It was common ground. The judge is not to be criticised for taking that date. It was common ground. And if your lordships would be kind enough to take Appendix 2, I can show you how the matter went. I hope quite quickly. At page 425, you will find yourself in the middle of Star's closing submissions. Paragraph 16 of Star's closing submissions on page 425 says the court has to assess what sum would have been agreed in a negotiation between winning grantor or winning grantee, open market, at the time Star Energy was seeking to acquire the right to use Bocardo's land, i.e. 1994. This is common ground. That's clear enough. And later on in the same case, page 445, I think, paragraph 106 of their closing submissions, they say, Star Energy submits that to ignore BP and Ryder is to adopt the wrong approach. The court is assuming a hypothetical negotiation taking place at the date of the breach, i.e. 1994. So that was their case. And that was the basis on which the trial was conducted and the basis upon which the valuation witnesses were examined. Now, there is an explanation which may assist your lordships as to why that date was taken.
As to why what?
As to why that date was taken, which is to be found at page 517. Now, this is in the middle of our, Bocardo's, submissions to the Court of Appeal. And we were seeking to make it clear to the Court of Appeal that certain matters had not been in issue at trial. And the first matter was the date of the trespass, by reference to which damages were to be assessed. And we give an explanation as to what happened, which is a little bit complicated, at the beginning of the trial. The original defence had contained an admission that the petroleum licence was transferred to D1, then called Cairn Energy Onshore, in 1989. We'd amended our particulars of claim to allege that D1 had been using the pipework since 1989 to extract oil, and D1 served an amended defence admitting that. That caused us to suppose that D1 had been the licence holder and well operator for the whole of the period since oil extraction started in 1990, and therefore the right person to sue. But at the beginning of the trial, D1 applied to re-amend its defence to withdraw those admissions. In support of the application, documents were produced which showed D1 had not been the petroleum licensee or the operator prior to 1994, when it became both the operator and owner of 25% of the licence. The judge granted permission to amend. The upshot was that the claim against D1 was now limited to the period from 1994. That was the date when D1's trespass began. That gave rise to the question whether that date was the correct one upon which to base the assessment of damages, or whether an earlier date should be taken. Both parties accepted at the outset of the trial, and we gave cross-references to the transcript, that 1994 was the correct date, and the case was then conducted and the witnesses cross-examined on that basis. The point was expressly accepted by D, as your lordships have seen, in its written closing. Had the right date been 1986, when PW5 was first drilled, the claimant could have relied on the fact that BP and Ryder had not then been decided, and the whole debate at trial would have been different. So it was a matter of some significance to both parties what the right date was, and it was common ground, it was agreed to take 1994. So to resile on appeal from that agreement, in my submission, is impermissible.
But had your evidence been directed to that date?
Our evidence had not been directed to 1994. Our evidence had been directed to 1990, when 2 of the wells had not been drilled at all. And our evidence placed no reliance at all on the fact that the wells had been drilled. Take it to Mr. Crawford's report. Mr. Crawford's report relies on a whole number of factors as being fed into the negotiation between the parties. But at no stage does he say, I rely in any degree at all on the fact that PW5 had been drilled in 1986. And therefore, of course, that would have given my negotiating position, given me a much stronger negotiating position. That was never part of his case. It was never part of our case when we opened the case at the outset. So his figures didn't depend on that at all. Now, it's fair to say that the judge did place some significance on the fact that at the hypothetical date, 1994, the wells were in position. He certainly did. But the significance was largely to do with this point about attic oil, because what was being said against me was, if the negotiation had taken place, Starr could have said, we won't drill under your land, we'll drill under Farmer Brown's. And part of my answer to that was, in 1994, you couldn't possibly have said that because you'd already done the drilling. But another answer, which is an equally valid answer, was to say, even if we went back to a much earlier date, when the wells had not been drilled, you wouldn't have done that, because you'd have had to deal with another landowner, and you'd have had to pay him nearly as much as you would have had to pay us. And you'd have rather paid us because you'd got more oil from us. So that was the way the debate went forward.
So it was known from the outset that the attic oil was where the pipe was directed to. I mean, ground surveys or whatever had produced that information. Is that right?
What happened was this, as your Lordship saw yesterday, Mr. Aaron, our expert, addressed the question, did the oil well have to go under Bocardo's land?
Yes.
If it didn't, obviously that was highly material to the question of the imaginary negotiation. He said, yes, it does. And he tried moving the site of the wellhead and targeting just past the south of Bocardo's land. And he found that that meant that you lost an awful lot of attic oil, 300,000 barrels or something. In the course of the trial, if I remember rightly, after Mr. Smith had given evidence for the first time, that's the valuer for Starr, Mr. Wright, the oil expert for Starr, produced this supplemental report which said, from Coney Hill, you could drill to a different target, which is along Bocardo's boundary to the north. But if you did that, that would be a suboptimal target. You would not get as much oil, and his calculation was the difference was 38,000 barrels, which was quite, well, significantly less, a lot less, than Mr. Aaron's alternative target to the south. It was sought to exploit that, Starr sought to exploit that by saying, well, in any negotiation which took place, one could have gone to the alternative target. And we could have said to you, Bocardo, you must reduce your price because we could go somewhere else. Our case was, no, you couldn't. That's a suboptimal location. The DTI would not have allowed it. And indeed, the experts initially agreed that the DTI would not have allowed it. But my client softened under cross-examination and said, well, maybe they would. And the judge found that they probably would, if we were being terribly difficult. So that's how matters stood at the end of the day. And the question then arose, well, what difference does that make to the measure of damages? Sorry about this explanation, it's rather convoluted. What difference would that have made to the measure of damages? It's quite interesting to see what Starr said about that. In the same bundle 2, Appendix 2, you can see their closing submissions on this point at page 448. And they didn't really amount to very much. It's paragraph 115.4 on page 448. It was submitted that, as Mr. Smith, their valuer, explained, it would make no difference to the licensee to deal with two people rather than one, and the possibility of getting nothing, should the rights be negotiated with a neighbouring landowner, would inevitably cause Bocardo to be willing to shift its demands downwards. This is because it was obviously better to have something than nothing, in consideration of land that would otherwise be of absolutely no value to the landowner, being so far underground. Star Energy submits that even if this was no more than a possibility, it is likely to have pushed the agreed price down by at least a percentage or more, 1%. I mean, that was the submission, that this factor would have that kind of effect. Well, the judge considered that and was not impressed. He did, in fact, push the percentage down by 3.5 points, but that was for a different reason.
Sorry, Judge, did it for what reason?
Well, he did it because of the effect of BP and Ryder.
Yeah.
The judge's thinking was BP and Ryder would have been a factor in the negotiation. We tried to persuade him that that wasn't right, but he didn't agree with us.
And all this is relevant now. Why? Because they're saying that the measure of damages is less than the judge.
Well, they're saying that the measure of damages should be based on a revenue of 38,000 barrels of oil at £10 a barrel. That's what they say in paragraph 195, and not the very much greater amount of oil that we felt should be based on. We were basing our 9% on, what was it, 690... I can't remember the full figure. It would have been, anyway, it was, we recovered from the judge £621,000, which was 9% of whatever the figure was on which it was based. And what is being said against us, it should only have been based on 380,000. But that's just the attic oil. That's just the attic oil which would have been lost by the alternative target on Farmer Brown's land. And it completely ignores the fact that Farmer Brown would have had to be paid for the rest of the oil, which could be recovered from his land. And that would have been a factor in the negotiation. That Farmer Brown would have insisted on being paid for access to his land, just as we would insist on being paid for access to ours. So that calculation is quite inappropriate in our submission. Well, the submission goes on at this point, and it criticises Mr. Crawford on a number of grounds. One is the date. Well, as I've said, actually, Mr. Crawford didn't make anything at this point. He actually valued as at 1990, and he made nothing anywhere of the fact that the well was in situ. That's point 2 on page 82 of my friend's printed case. Point 3 criticises Mr. Crawford for not being able to give any comparables, but there's a jolly good reason for that, because there weren't any.
Sorry, which point?
The point 3 at the top of page 83. These are the 4 criticisms of Mr. Crawford. I've dealt with the first 2. Criticism 3 is Mr. Crawford was not able to give any comparables. Well, of course he wasn't, because there weren't any, because oil companies had taken the view they didn't need any rights. And they'd been burrowing away underground without asking anybody. And then it said that Mr. Crawford relied on inappropriate comparisons with surface access payments made for open cast coal. Well, he did rely on surface access payments for open cast coal as a cross-check right at the end of his valuation. But Mr. Smith criticised that. Mr. Smith was cross-examined, and about the very matters which are raised here, and the judge, having heard that cross-examination, was prepared to accept Mr. Crawford's evidence, subject to the 12.5% coming down to 9%. So in my submission, my lord, these are very much matters for the trial judge. He heard the witnesses. He was familiar with the course the trial had taken. He heard the witnesses cross-examined. He made various findings. If he got the law right, then in my submission, his award ought to stand. And it oughtn't to be interfered with by an appellate court, which is not as familiar with the course of the trial, can't be, and didn't hear the cross-examination of the witnesses.
Yes, well, that's a fairly short proposition, I think, having after the introduction. Yeah.
My lord, finally, it occurred to me that it might be helpful if I just dealt with 4 points which arise in the case of the intervener, the Secretary of State, and then I'll sit down. And your lordships have the intervener's case in the core volume. I don't intend to go through this at all. I'm just going to pick up 4 points. And the first arises under paragraph 36. What the Secretary of State has pointed out at this stage is that Section 1 of the 1934 Act vests the oil in the Crown, a proposition which we do not challenge. And he says in paragraph 36, this state of affairs is fundamental to the assessment of the value of any ancillary right, which comes to be granted to enable a Crown or a designated licence holder to exploit such petroleum that may exist. While the landowner may be able to grant access to his land to facilitate the search or boring for petroleum, so it seems to be accepted, at least by the Secretary of State, that the landowner can control access. He cannot himself, the landowner cannot himself grant any right to search or bore for petroleum or get that petroleum that may exist underneath his land. Absolutely right. Thus, says the Secretary of State, when a landowner grants a right of access to facilitate the getting of petroleum, the landowner is not giving up or relinquishing any right of access the landowner could himself exploit or transfer to any other person. Wrong. The landowner who controls the access, if he grants a right of access, is giving up that control. The fact that he doesn't own the oil is neither here nor there.
But he couldn't transfer it to any other person.
He can't transfer, well, I think what the Secretary of State there means is the landowner can't exploit the oil or transfer the right to exploit the oil to any other person. He certainly can't do that.
No, he's saying
But
there's only one person who wants the right of access. Isn't that?
Yes. But that's not what he's saying here.
Isn't he?
What he's saying is when the landowner grants a right of access, he's not giving up or relinquishing any right of access he could exploit. No, he's not giving up a right he could exploit by extracting oil, but he is giving up a right which he can exploit because he controls the access. He's giving up the right to control the access. That is a right which he still has, as the Secretary of State, I think, concedes in the previous sentence, where he says the landowner may be able to grant access to his land to facilitate the search or boring for petroleum. Indeed, he can.
Well, all that's being said is the landowner hasn't got any commercially exploitable right other than the ransom value.
Yes.
Exactly.
Well, what the Secretary of State does not accept, I think, is those last words, other than the ransom value. The Secretary of State is submitting he's got nothing to sell. He's got nothing because he can't exploit the oil. But my point is, yes, he's got a bargaining position. He's got the ransom value.
But the final sentence makes clear that the Secretary of State is not talking about ransom value.
No,
He's only talking about commercial exploitation.
The Secretary of State is ignoring the ransom value.
Yes.
Well, the last sentence does rather suggest, well, if you can't, if you suffer no loss in respect of exploitation of any petroleum,
Yes.
and because you're not being caused any inconvenience, you shouldn't get anything at all.
Yes,
that's the logic of it, really. And you're saying, well, there is some value here because you could have said, leaving aside the statutes and so on, I'm sorry, I'm not going to give you this right without
Yes,
paying for it.
That's what I'm
I
saying.
mean, I think that's all you're really saying, isn't
That is all I'm really saying.
And that's what the whole case is about.
That's what the whole case is about. The thrust of this paragraph, I would respectfully submit, is that the Secretary of State is saying, you haven't lost anything. You haven't lost anything at all. And I challenge that. I say, we have. And if I might then ask your Lordships to look at paragraph 42. Paragraph 42 is probably the main concern of the Secretary of State. See, it's a wholly legitimate concern. He submits there that if the 1966 Act were construed so as to allow the grantor to take account of the special value of the ancillary right to the grantee, and then the 10% were applied, this would be capable of rendering the exploitation of some onshore petroleum uneconomic. Now, I can see why the Secretary of State would be worried about that perfectly properly, but it proceeds on a misapprehension in my submission. The bargain that I have suggested to your Lordship, the landowner and the oil company make, is a fair and reasonable bargain between willing parties. It's not one that is forced upon the oil company. It takes account of the profitability. Ex hypothesi, it is not uneconomic. If it were uneconomic, the oil company would not be willing to make it. If it were such that it inhibited the exploration for oil and made it not worthwhile doing, then that's not the bargain they would make. The bargain we have suggested here, for example, is a bargain which leaves very much the lion's share of the profit with the oil company. It makes it very well worth their while. I mean, we are looking here at them paying us, according to the finding of the judge, somewhat over £600,000 in respect of something like £10 million worth of oil. Now, that's leaving in their hands 3/4 of the profit. So it's not that's 3/4 of the profit after they've paid all the overheads and depreciation and what have you. So that's not making it uneconomic at all. We are not suggesting a construction which would make it uneconomic. We're suggesting an approach in which the measure of the compensation is, as I put it, ex hypothesi, economic. It's financially viable. If it were not financially viable, that deal would not be done.
Under the judge's award, what proportion of the net profit is left with the Star?
Well, my lord, it went like this. The 12.5% of revenue was estimated by Mr. Crawford to be 25% of profit.
What, net profit?
net profit.
And is that after paying the royalty as well?
Yes. So the 9% was obviously
Right.
left them with more profit. I haven't worked out exactly what the maths would give, but it would have left them with more.
Something like 3/4 of 25.
Well, indeed. So it certainly didn't make it uneconomic, and our approach in principle does not make it uneconomic.
Yes.
And then paragraph 54, the Secretary of State says, as to taking into account the special interest of the licence holder in acquiring the rights, the Secretary of State submits that this is a legitimate approach, provided it's confined in its application in the way identified in Ryder, as modified by the Court of Appeal. The special value will be reflected in the value to the grantee of the rights, because the licensee would be prepared to pay more to secure those rights than those interested in purchasing the same land for its existing use. It hasn't actually got any existing use, 3,000 feet underground. But the importance here is that the Secretary of State does seem to be accepting that, as did Mr. Justice Peter Gibson, that the special interest of the licence holder in acquiring the rights is to be reflected, but he says, do it as in Ryder, and we recall that in Ryder that accounted for £5 on top of existing use value. And he says, do it as in Ryder, as modified by the Court of Appeal. Now, the Court of Appeal's approach was £50 for a deep tunnel, doesn't matter how long, how deep, how big, where it is, plus 25% for the oil, that's the special interest of the licence holder, plus 10% under the Act. The Secretary of State is saying, that's fine, I'm quite happy that you should take into account the special interest of the licence holder in that way. But I've made my submissions to your lordships about that. That is a quite bizarre approach, which really doesn't reflect the special interest of the licence holder at all. It's just £25. And the Secretary of State, I think, appreciates this, because at paragraph 89, he
Is
says,
this your fourth point?
this is my fourth point. Paragraph 89, he says, the Court of Appeal awarded an uplift of 50% to account for the fact that the respondent, as the holder of the petroleum licence, is a special purchaser. Without commenting on this particular finding, the Secretary of State endorses the general proposition that any uplift should only reflect what is fair and reasonable in each case. The Secretary of State is not seeking, I think, to put his weight behind the £25.
I mean, I thought that, really, I mean, the whole of this argument hinges really on the proposition, page 12 of this argument, the end of paragraph 38, the beginning of paragraph 39, which, so to speak, takes it as a received truth in this context, that actually, you know, you ignore the value of the scheme, or in this context, you ignore the landowners, the oil company's interest in extracting oil.
Yes, well,
I mean, that's your root and branch attack on this.
that's my root and branch attack, but there is a constant inconsistency here in both Ryder and the approach of the Court of Appeal, and, if I may say so, the approach of the Secretary of State. On the one hand, they say, you've got to forget the oil. You've got to forget the oil field. That's the scheme. That's all got to be left out of account. And then they say, but it doesn't wholly have to be left out of account. The special interest of the petroleum licence holder can be reflected. How? One more bit. £5, £25. That's how. But that's wholly unrealistic.
That would.
That's wholly unrealistic. I mean,
One doesn't value the key, is your point.
the key's my point. One's got to go one way or the other. Either the interest of the petroleum licence holder is to be taken into account, in which case it's worth serious money, not some nominal sum, or it isn't to be taken into account at all. in which case it's not even worth £5 an acre or £25. It's got to be one or the other. It can't be both at the same time. My Lord, those are my submissions, unless I can assist your Lordships on any particular point.
Thank you very much indeed.
Thank you, my Lord.
Mr. Beloff.
Why don't I just give you this?
Just to see how we're getting on timing.
I'm very conscious.
There's a certain amount of latitude, I think, built into the programme, but on timing you should finish at lunchtime, but maybe you run on a little longer.
I was going to say we should finish before the kick-off this afternoon, but I realise that won't affect your Lordships one way or the other. My Lord, I have, as your Lordship will know, from the agenda that my learned friend Mr. Gaunt put forward, two functions. The first is to add a brief footnote to his arguments on construction of Section 8, subsection 2 of the Act of 1966, and to the claim for damages for trespass by reference to the Human Rights Act. Now, this was not a point relied upon below, and my Lord, the Vice President's observation before the adjournment suggests that that omission may not have been wholly unwise. But I should emphasise, my Lord, that the point is in any event clearly not necessary for Bocardo to succeed on their appeal on damages. Secondly, to deal preemptively by agreement with the argument that no right to damages for trespass accrues at all to Bocardo, since there was no trespass by Star. Now, my Lord, I was invited to be very brief in relation to the Human Rights Act, which may be a euphemism for an invitation to abandon it completely. But, my Lord, I shall, if I may, try to keep it alive by reference to our printed case, which sets out the essential submissions. And I shall deal, of course, with what appears to be troubling in particular, my Lords, which is that the argument is anachronistic because we are seeking to apply the Human Rights Act retrospectively. And in order, as it were, to counter that particular point, my Lord, it's necessary simply to set the scene as to how we put the matter. If your Lordships would be good enough to go to page 34 of our printed case, and at paragraph 102, your Lordships will see that what we contend is that a construction of Section 8, subsection 2 of the 1966 Act, which has the result of entitling a party in Bocardo's position to either the value as Star's assumption of £82.50 or even to the Court of Appeals figure uplifted to £1,000 would be by way of compensation for granting a right for which he could, in open market negotiation, as the judge at first instance held, obtained a sum of over £600,000, would be incompatible with Article 1 of Protocol 1 to the Convention. Now, in our submission, there are 4 points that I make at the outset which are wholly uncontroversial. Firstly, that the Human Rights Act requires primary legislation to be read and given effect to in a way which is compatible with Convention rights as far as possible. That is Section 3, that it applies to such legislation whenever that legislation was enacted. That's Section 3(2)(a). Thirdly, that it's unlawful for public authorities, which include courts of law, to act in a way incompatible with Convention rights, which is Section 6. And fourthly, that the courts in this jurisdiction, in determining questions which have arisen in connection with a Convention right, must take into account inter alia judgments of the European Court of Human Rights, that's Section 2(1)(a). And indeed, the jurisprudence has reinforced that by saying that that is to be the general rule. My Lord, against that background, it's necessary to identify what is the property right in issue, and we put it in the way reflected in the jurisprudence, for example, in the judgment in Markham that my learned friend read to your Lordships, that's volume 6, 68, page 267, as simply being the right which we enjoyed as landowners to control access to the land and to the subsoil and accordingly to the oil that was located there. One might put it in an alternative formula that we had the right to charge for that access, but in either instance, the unlawful trespass has deprived us of that right. It's to be noted that we were deprived of that right by these particular respondents from 1994. That comes from the Statement of Facts, paragraph 7 at page 6, and they continued to deprive us of that right up to 2007. That's paragraph 27 of the Statement of Facts at page 7. Prior, of course, to the 2nd of October of 2000, the property right that we enjoyed would not be described as a convention right in terms of our domestic law, but after that date, in our respectful submission, it was. So against that background, we set out in paragraph 106 four well-established principles: the fair balance principle in relation to Article 1 of the first protocol that was first articulated in Sporran and Londroth, and has been a melody played by the Strasbourg court ever since. Secondly, that even if one is in a situation where the litigation is between two private parties, nonetheless, the state's responsibility will be engaged when it has itself enacted legislation which confers certain rights on private persons. Pye and Oxford was a case, James and the United Kingdom involving the leasehold enfranchisement legislation was another, and tangentially, at any rate, as my Lord the Vice President will recollect, the Aston Canslip case, the Chancel repairs legislation, also came into focus there, although the decision was based on other grounds. The third proposition is that the ordinary position is that one should pay pay compensation of an amount reasonably related to the value of that which had been deprived. That is the James case. And fourthly and lastly, the former King of Greece case. Your Lordships will remember that he had his estate expropriated by the state for nominal compensation, and that to justify such a conclusion requires a convincing explanation and objective justification. Now, my Lord, contrary to what Starr says, this is not a question as to whether or not the Human Rights Act would have been factored into the negotiation between the parties. We rely upon it, for present purposes, to factor it into the legislative phrase of what is fair and reasonable. So that's the first way in which we put it. We simply say it could not be compatible with human rights, have a fair and reasonable compensation that results in the figures that were contended for by Starr and upheld by the Court of Appeal. The alternative way of putting it is the way that we put it in relation in paragraph 108, which is to look at it not from the perspective of the construction of the legislation, but from the perspective of this being, as it was pleaded, a claim in a trespass, to say that the courts, as public authorities, should develop existing causes of action, even if not to create new causes of action, in a manner compatible with the Convention. And we cite from an observation of Baroness Hale in the Campbell and Mirrors newspaper case, and we say that trespass being a recognised cause of action, it and damages or compensation given for it ought by the courts to mirror the presumption of fair compensation in the Convention and its jurisprudence. Now, my Lord, it's against that background that we engage with the retrospectivity argument.
And the argument against you, just to get our bearings, is set out in, I think, paragraph 172.
172, and I think my Lord referred yesterday to 113 as well.
113 as well, perhaps, yes.
But 172 to 3 reiterates the point.
Yes.
Now, in our respectful submission, the method, what the legislature has provided for in Section 8, subsection 2 of the 1966 Act is a method by which the court is going to make an assessment of what is fair and reasonable compensation within the criteria there set out. And the negotiation that's been referred to, and indeed is referred to in the printed cases, is an entirely hypothetical negotiation which never took place, and it's simply a method of evaluating what is fair and reasonable compensation. And in our submission, that approach ought to engage at any time when Star needed to acquire or to maintain their right of
You
access.
say the critical time is when the cause of action accrues, do you?
Yes, we accept. What is peculiar about this case is this. Our cause of action originally accrued in 1994. Because of limitation considerations, it was recognised that we could not, in fact, bring a claim before the 27th of July of 2000. That is a few months away from the coming into effect of the Human Rights Act, and we will generously sacrifice any claim based on that intervening few months. But what we do submit is this. Since at any stage had Bocardo become aware of the trespass, they could, for example, have gone to the court and asked for an injunction. Indeed, your lordships will recollect that Mr. Justice Peter Smith granted them an injunction subject to terms, even as late as the trial at first instance. In those circumstances, the issue arises, well, during that particular period, during which the Human Rights Act is in force, why should the court not apply the jurisprudence to what is considered to be fair and reasonable over the period to which, in which the trespass continued? Or if one looks at it the other way round, as simply being a claim for a continuing trespass, and that the court is under an obligation to develop the domestic jurisprudence compatibly with the convention jurisprudence, why is one not then entitled to say, under the convention, what would be regarded as appropriate compensation would be that which reflects the value of that which you've lost, which in this case is the right to refuse access to outsiders, and accordingly reach the same destination. Really what Starr's case comes to is this. If the trespass had commenced prior to the, only after the 2nd of October of 2000, the Human Rights Act would have been potentially engaged, I put it that way because there may be arguments of substance, for a period up to 2007. But merely because it commenced prior to that date, then they say the Human Rights Act is not engaged at all, even if the trespass as is common ground, if trespass at all, continued past that date. That's, in short, the answer to the retrospectivity point, and why we respectfully submit that this remains a viable addition to the points of construction contended for by my learned friend Mr. Gauntlet, and in any event in relation to the pure claim for trespass and its damages.
I mean, did the owners in the of the wetlands in Waters miss a trick in not arguing the Human Rights Act in respect of what compensation they were entitled to? Is this, do you say that?
Well, my lord, I'm not, I'm aware of the Waters case and I've looked at it. I'm not sufficiently familiar to be able to respond.
Are you saying there's something wrong with legislation which says, if it says clearly, the basis of compensation ignores the scheme, or it said here, the basis of compensation was to ignore any interest in gaining access to the Crown's oil? I mean, you're not saying that would be contrary to the human rights?
Well, we don't need to go that far in this case, because what we are saying is not, this is not seeking a declaration of incompatibility. What we are saying is that human rights considerations and the jurisprudence on Article 1, First Protocol, feeds into the construction that your lordship should give to a section the centrepiece of which is the concept of what is fair and reasonable.
So
That's the way in which we put it.
So we're not in the section 6.2 problem,
Yeah.
you know, where one's giving effect to legislation which can't be read compatibly and
This
so on.
is
You're saying
all
it can be read compatibly
Absolutely.
under section
We
3.
say it should be read in that way in any event for the reasons Mr.
But I mean,
Gordon
is it a
articulated.
possible view on the submission that Mr. Justice Peter Gibson was right in BP Petroleum, because that was before the Act, but we've now got to construe the same provision differently? I mean, is that a...
Well, there's no doubt that the provision has to be construed now since 2nd of October 2000 in a particular way. What, of course, doesn't necessarily follow, as Lord Nichols said, for example, in the Wilson case to which my learned friend refers, that necessarily then you can have a cause of action retrospectively. We recognise that by saying we're not concerned for present purposes with the position between 1994 and the 2nd of October 2000, but we have a continuing viable claim for a period, all of save for 3 months of which covered the human rights. So, my Lord, I hope I've dealt, as it were, with sufficient brevity with the point, and at least encourage your Lordship to believe it was not an entirely foolish additional footnote to the arguments that Mr. Gauntlet has said.
I think you put the point very clearly. I can say
If
yes.
if the claim had not been time barred earlier, the measure of damages would be significantly greater, would it?
Yes, but then the human rights considerations wouldn't have come in relation.
They'd kick in halfway through, though, would they?
Yeah, they kick in.
The cause of action.
Oh, I see what you.
The cause of action arose in whenever it was,
Yes.
and proceedings had been begun within the original time limit, so there was no time bar. Then the measure of damages would be greater, but the section would have to be construed differently halfway through.
Well,
Is that the way it would work?
Well, that's assuming that we're saying that the section has to be construed differently. Our position is
I follow
that
that,
this is
but
reinforcement.
this point only arises on that hypothesis.
Well,
I mean, if you're going to win anyway, well, then you're going to win anyway.
Yes.
But I'm not saying you're wrong
What
about
we're
that. But
saying-
that would be the logic of your position.
It would be the logic of the position, but what we, of course, are saying, and in company with Mr. Gauntlet, is that it has been misconstrued by the Court of Appeal.
But on my example, you'd have the measure of damages would be assessed on the basis of construction A up until the 1st of October 2000, and thereafter, for all the continuing trespass thereafter, it would be assessed on a
We would have to accept that in principle.
And is that because of section 22 of the Human Rights Act, or
Yes.
just...
Yes.
Because that has a provision against
Effectively,
retrospectivity.
that's why Lord Nichols in Wilson and my Lord the Vice President in other cases has been careful to identify the limits to which there is any retrospectivity in the Human Rights Act. We're not contending for retrospect. We are simply concentrating on the period between the 2nd of October.
You say that the whole of this cause of action, or the surviving cause of action at any rate, is post the Human Rights Act, and therefore there's simply no question of retrospectivity arises.
Exactly so.
And there you have it.
That's it. So, my Lord, may I then move on?
So that still leaves my Lord's point as to how you apply the Human Rights Act.
Oh, of course, and that we've set up, and as I say, we've got two ways. A, the construction of the subsection. B, simply the development of the common law cause of action in trespass in a manner, including damages for it, which is compatible with the convention jurisprudence.
Well, I'm sorry to keep going, but I mean, why couldn't you have a perfectly good common law approach to trespass? I know it's not the way the common law in fact has gone, which simply say, well, if you only get damages for trespass if you can actually prove you as the landowner have suffered loss by the trespass.
Well, what we say is, once one accepts that we have a valuable right, whether one calls it a key or a ransom strip, one would then say that the convention jurisprudence is that you should have fair compensation for deprivation of a valuable right. Not quite in para materia with the Duke of Westminster, who lost significant property, but the general principle can be extrapolated to anything that is an identifiable property right of value of which one has been deprived.
Yes.
My Lord, then, at least having been faithful to my undertaking to be brief on the first of the 2 points, may I now move to the second and more substantial point?
This is a point upon which you won.
This is the point on which we won. I'd have at least that consolation.
I think I raised the question yesterday, so I think it was better to wait for your opponent to speak, but I think it's been agreed.
It's
that you
been
should say
agreed, my
something
Lord, and I
about it
can
now.
deal with it.
Yes.
Both cases have been very fully articulated in the printed cases. And really there are three propositions. In fact, there were four under the trespass issues. The first is that Bocardo, as registered freehold proprietor of the Oxted estate, owns the shrub strata up to, at any rate, and I put it this way, I don't need to put it, up to at any rate the point where Star were invading by their drilling. Secondly, that the invasion of those substrata constituted the tort of trespass. Thirdly, that Bocardo enjoys the cause of action in trespass. And fourthly, that Star's license did not authorize it to access oil through Bocardo's land. Now, the fourth and last of those has already been dealt with by my learned friend, and I will deal with the first three, in which there is a considerable measure necessarily of overlap. Now, as my Lord Clerk has pointed out, in this instance, we are seeking to uphold the decision of the Court of Appeal, in particular paragraphs 60 through to 62 of the judgment of Lord Justice Aikens. What your lordships may have noted, whether with enthusiasm or despair, is that far more authority is put before the Supreme Court than was put before the Court of Appeal, partly in response to the more elaborate resurrection of the point by Star in their petition for permission to cross-appeal, but secondly, of course, as is common ground, if Star were correct on this point, then the damages issue does not arise at all. Therefore, it's obviously of critical importance to Bocardo to uphold the decision of the Court of Appeal. Now, my Lord, the starting point is that we are, as see the statements of facts, paragraph 1, the registered freehold proprietor of the Oxted estate. We say that it is trite law that a conveyance of land, unless there have been exceptions from the grant, includes the surface and everything below it, so that Bocardo owns everything other than the petroleum itself, having acquired it as part and parcel of the estate. The position that reflects, as it were, the Latin brocard maxim, call it what you will, cuius est solem eius est usque ad coelem et ad inferos, is something that has, as it were, a civilian derivation, but was first, at any rate, first authoritatively made part of English law in Blackstone's commentaries. This was not, I think, put before my lords, but I have the extract from those commentaries, and you will see how Sir William Blackstone put the matter in his Laws of England.
And is the maxim a declaration as to ownership?
Yeah.
I mean, there's a distinction possibly between
Ownership and
rights,
yes,
of a more general kind, or actually the ownership. Because if you own property,
yeah,
that has a significance in itself.
yes.
And you're saying that that is the position under the brocard.
Yes. And we say that that remains, as it were, the default position. I'm going to make some general observations before coming to the commentary and the jurisprudence. But your lordship sees it, that although Blackstone, this is at page 18 of the extract.
We don't at the moment have a copy of this.
I'm so sorry.
Very grateful.
Although Blackstone recites only a part of the brocard or maxim, that's to say the usque ad coelum part, midway down the page you see that downwards whatever is in a direct line between the surface of any land and the centre of the earth belongs to the owner of the surface, as is every day's experience, as he puts it, in the mining countries, except where there is a custom to the contrary. And then he amalgamates, as it were, both parts of the maxim. So the word land includes not only the face of the earth, but everything under it or over it. Now, we submit, we make the following general submissions. Firstly, in our submission, the jurisprudence, both English, Scottish, and Commonwealth, is consistent with this as representing the law, as is the predominant weight of academic authority. And although it is true to say, in a technical sense, that there is no binding precedent binding upon this court to the effect that the surface owner owns all that is underneath, in our respectful submission, were your lordships to accede to the invitation to depart from that principle, it would be in contradiction to very well established jurisprudence. The second general point we make is that the test that is there adumbrated has the essential legal virtue of certainty, which is especially important where property rights are concerned. The third point that we make is that in practical terms, the only question which arises is who owns the property and land below the surface so far as man can actually penetrate now or at the time of future cases as and when they arise. If there are depths, the molten core of the earth, which man has not and never will be able to penetrate, that question of ownership is academic, and it certainly does not arise in this case. We're not asking your lordships to take on the guise of some judicial Jules Verne and journey to the centre of the earth. That is simply not a matter that needs to be decided in this particular case.
But is the point then this, assume that you're dealing with a level of the substratum which man can reach, and somebody wants to do something with it. The question immediately arises, who owns that stratum? Either it's res nullius, nobody owns it, or it belongs to the Crown, but nobody's suggesting
No one
that.
has suggested.
If it doesn't belong there, you're saying the logical thing is to look upwards to the boundaries of the land above it.
Well, but not only it's the logical thing, it's the way in which the courts have hitherto interpreted it. And what we say, which is the fourth proposition, general proposition, is that this particular case is no different in principle from the cases that we've cited in the printed case. The fact that the incursions in this particular case, reflecting modern technology, may have been somewhat deeper than the incursions in previous cases in the casebook is not a difference of principle at all. One applies the same principle in our respectful submission to this case as one did to the others. The fifth general proposition is that the rule that the prima facie, and that's, of course, always subject to exceptions, the owner of the sex, which could be statutory exceptions, exceptions relating to property rights which are juxtaposed or qualify the rights of ownership, but the prima facie, the owner of the surface, owns all beneath, is a perfectly workable and practical rule, in particular if, as Starr asserts, man's underground incursions are and always would be confined to the outer parts of the Earth's crust. And then finally, the seventh point is that Starr's alternative test, and here we invite your lordships to look at that, which is at paragraph 70, at page 28 of their printed case. The title to land, as they put it, should be determined by what is necessary for the ordinary use and enjoyment of the land at any particular time. If it's necessary for the surface owner to use a substrata for the ordinary use and enjoyment of his land, then subject to some private or public law which prohibits it, the surface owner should have the right to make use of the substrata. Now, my lord, what we say in relation to that is the very language betrays the fact that this is lex ferenda and not lex lata, should be determined as the language of revision rather than a statement of the present law. And it may be, make no concession since it doesn't arise, that alternative test may, if I may adopt a saying from another context, it may have the hope of posterity, but it certainly lacks the pride of ancestry. If the hallowed law requires refinement or revision, we say that is a matter for the legislature. But one is bound to note that what is contended for by way of what the law should be is, in our submission, revolutionary. The question of whether A owns a particular tranche of land and the question of what A wants at any particular time to do on that land, or indeed what the reasonable or ordinary person in A's position might want to do in that land, are entirely separate questions. I mean, the ransom strip is a classic example. It may be unused, it may be unusable, but nonetheless it would be accepted that the person who was the freeholder of that particular land would be its owner, and it would have very considerable value. And of course the airspace cases, I shall come to later, don't demand that a person only has a right of trespass if, for example, the oversailing crane were to affect use of the airspace that he himself wished to make. Those simply point up in our respectful submission how far away from the present state of the law my learned friend's suggestion is.
You drew attention to the phrase title to land.
Yes.
And do I understand your reading of this paragraph to be this, that they're asserting that there is no title to land which has got so deep that the land is wholly unusable? Would that be how it's supposed to work? That you have so long as it's usable, obviously if it's close to the surface and you need it for working the surface and so on, therefore you have a title to all of that. But the deeper you go, the more unusable it is. The title sort of disappears to a point where it doesn't exist anymore.
We read it as a slightly different way. Here, it appears to be suggested that what's necessary for the ordinary use of enjoyment at any particular time is tied to the position of the surface owner. And indeed, for my learned friend's argument to succeed, that is the way in which it has to be put, because we understand what he says is Bocardo had no ability to access this particular subsoil, and therefore they had no use or enjoyment. It was not necessary for their use and enjoyment, and therefore they would be disqualified on this interpretation of the law to be able to assert title, and as we shall submit at a later stage in consequence, to assert possession or right to possession for the purposes of generating a cause of action in trespass.
It's odd, though, isn't it? Because Star are using the substrata for their ordinary use and enjoyment.
Yes. Well, I mean, your Lordship has, in a sense, the point I make. If one is going to limit this in it were practical terms, then a solution might be to say the owner of the surface owns all that beneath it up to the point where anyone with the use of modern technology can make use of it, but if below that no one can access it, so be it.
And if we take the crane, case, then how does it work with the crane case?
Well, my learned friend's hypothesis doesn't work with the crane case, because the crane's cases do not depend upon the person who obtains the injunction having any use of the airspace above. It isn't said it has to interfere with use he wishes to make. The Crane cases are simply based on the proposition.
It would have to be based upon the use he could make,
Yes.
not the use he was making.
Yeah, title can't depend on the identity of the owner.
No. Well, no, it can't. But we say there are all kinds of complications in seeking to modify the traditional law, and those type of complications might very well be fitting for legislation.
I mean,
but they're
otherwise,
not.
it look as though there'd be complete free-for-all. You get to the point where the owner of the surface really can't possibly get at anything, but there are other people coming from different directions, and I mean, it's a curious situation that they can just burrow around without regard to anything.
Yeah, well, yeah,
I mean,
exactly. I mean, one can multiply, as it were, the problems that would arise in refining the ordinary test. Much simpler to say, that's the test, the default position. Actually, it won't matter when one's dealing with strata below the surface, molten core, it may be a little upwards, that no one can access in any event. It then becomes purely a question for a university moot. Not a question for a Supreme Court.
Did Blackstone's commentaries focus on the air position as well as the subsoil position?
Yes, your lordship will see. I simply didn't read that section. That is just under where he cites the maxim. He says, upwards, therefore, no man may erect any building or the like to overhang another's land. So he's dealt with those. He just happened to have cited only half the maxim.
Yes, I mean, the various notes being passed to me, I think the position that the court is in is that we've read what you put in your case, and we really don't need more oral argument to develop the point you're making, because it seems to us quite straightforward. The only qualification that's reaching me is a little clearer position as to how one deals with cranes in the air. We've got the authority we've got for subsoil and everything to that effect.
Yes.
But it's a little obscure as to exactly how the courts have rationalised the right, if any, to stop somebody moving a crane over your property.
Well, I mean, it's not this case, but
No.
cranes, no, aeroplanes, okay. I mean, what's the principle?
I mean, one of the points we make, I don't know to what extent your lordship wishes, as it were, to say enough has been said already or enough has been written already. One of the points that I was going to engage with is whether one can make any read across from, for example, the position taken by Mr. Justice Griffiths, as he then was, that the usque ad coelum part of the maxim cannot be sensibly applied. And my learned friend, on the basis of that, seeks to suggest that similar considerations would mean limitations on the right to downwards. And we dispute that for a number of reasons that I can articulate and are partly set out in the printed case. But again, I'm very much in your lordship's hands as to how to deal with. Can I make it clear? I was not proposing to do more than, as it were, give your lordships the references that we have in our printed case, and then make certain very short submissions on the basis of those references.
I mean, the references are there. I don't think we need to be taken to them. And the only point I would make is that because points are made against you that we're talking about the United Kingdom law, I would caution against that, because Scots law, property law is different.
It is different.
And nothing that would be said here would affect the position in Scotland.
Yes, and one of the interesting features is that the Scots laws, one sees from stare, doesn't necessarily accept the qualifications that Mr. Justice Griffiths made about what the common law position would be. They regard this as being a matter which has been sufficiently dealt with by legislation.
And we needn't get into that area.
We needn't get into
So
that.
I think what you can take it that we've read the comparative law that you've introduced and all of that. And I don't know whether Lord Brown would be content to hear how it's put by those against you. It might be best to leave it, rather contrary to what we suggested before, and see exactly how the point is put. That is the usque ad coelum point against you, and you could comment on it by way of reply. Would that be a convenient way to proceed?
I'm entirely in your lordship's hands. Does that mean that your lordships equally have read the proposition that we make in favour that the right if the cause of action in trespass inures to us because we have either possession or right to possession
Yes, yes.
as well.
Yes.
We've set that out fully, and again,
We'll
we're in a
come back
position
to it in
to
replies.
debate the contrary case, but if your lordship, and I can well appreciate, given that there is a certain amount of slippage of time, it may be better to
Well,
deal
it's not
with.
because of time pressure that
Yeah.
we're taking this
No, but-
position. It's simply that we have enough before us to proceed and listen to the argument against you. And if there are points that trouble us as the argument proceeds, then of course we'll come back.
Yes, I mean, can I then just just simply remind your lordship of one matter that we do cite from the case, from the commentary in relation to New Zealand, which your lordships will have found at paragraph 121 at page 41. And I just, if I may, as it were, before I resume my seat, just remind your lordship of what is there said. The learned author there, the latest edition of 2009, says it's clear the possession enjoyed by the occupier of the surface of land extending to the subsoil beneath. Possession is also important in that context for the trespass. It seems generally accepted that any intrusion into the subsoil beneath the plaintiff's land will constitute trespass. And this is the point we want to emphasise. There appears to be no case in the Commonwealth where a plaintiff has failed on the basis that the area invaded was so deep that the surface occupier's possessory rights did not extend that far. And in a sense, we pose a challenge to my learned friend Mr. Driscoll to produce a case that undermines that proposition, as I say, authored in 2009. And then the old test of Usquert Coilemeyer Infres offers the great advantage of certainty, and the better view is that it should remain the law.
That's Mr. Justice Griffith's wrong point.
Yes, that would be. But in any event, your lordships, again, I don't want to be tempted as a respondent, we do say there can be differences identified. And indeed, the very books, Megarian Way, to which my learned friend refers, do say airspace is different for obvious policy and other reasons. My lords, I'm now going to not do that which my Lord the Vice President invited me to do, which is sit down. So I shall sit down and reserve response.
Well, thank you very much. Mr. Driscoll.
Whilst logically, perhaps, I should deal with what have been described as the trespass issues, what I propose to do, if I may, is begin with the damages issues and come back to the trespass issues later.
Yes.
And so far as the damages issues are concerned, what I propose to do, again, is to deal with the argument based on the assumption that this is an exception to the general rule, and this is a case where one must consider what would be an appropriate sum to award by way of a user or way-leave damages. We do have an argument that this is a case where the general rule as to damages should be applied, and that is by reference to the loss suffered by the claimant, rather than by reference to the gain that has been made, or is estimated to be made, by the trespasser. But if I may, I'll come back to that argument after I've dealt with the argument based upon user damages, way-leave damages, route and park damages, negotiating damages, however they might be described. Our case is simply this, if I can just summarise it, and I'm absolutely sure that your lordships have this well in mind. Our case can be reduced to 6 propositions. First, this is compulsory acquisition legislation. And by this, I mean the 1966 Act, the Mines Working Facilities and Support Act 1966, read in the context of the 1934 Act, the Petroleum Production Act. Secondly, in the context of compulsory acquisition legislation, compensation reflects simply the value of the right to the owner and not the value of the right to the acquirer. This, I suspect, may be one of the issues, if not the issue, whether or not that is right, the right approach to valuation in this context. Thirdly, the value of the right to the owner cannot include any value which is only enjoyed by the acquirer and then only because of the statutory scheme for the purpose of which it has been able to acquire the right. This is the no scheme principle, sometimes referred to as the Point-Gord principle. That's the third point. The fourth point is that the statutory scheme in this case is, I quote now from Lord Justice Aikins, paragraph 111, page 38. The statutory scheme is, quotes, the exploitation of the petroleum licence in the specified area.
This specified area, or the?
The or this specified
Well,
area.
it's a quote, so it'll be one or other.
The specified area.
Thank you.
The fifth proposition is that the nationalisation of oil in 1934, together with the grant of the exclusive right to bore for and search for and get petroleum in the Crown, deprived the landowner of any value that there might have been in his land because there was an oil reservoir underneath it.
Can you just repeat the last words? Deprive the landowner of?
Any value that there might have been in his land because there was an oil reservoir beneath it. And as part of the same point, from 1934 onwards...
Is this 6 or is part of 5?
No, this is still 5. From 1934 onwards, the only means of exploiting the oil was through the statutory scheme of licensing. And the final point, 6, is if one ignores the value of the right to the acquirer, in this case, the license holder, the right to drill pipes through the substrata is of no value, is non-existent. Value is non-existent.
Sorry, the right to drill pipes?
Pipes through the substrata is
Through the
non-existent. In the no-scheme world, there is no market for it.
This is the right, you mean the right belonging to Star, for example?
Yes.
Would it be possible, in case I just haven't got an absolutely clear note of all of that, to have that in a typed version?
Of course it would, yes.
Yes, it would be rather more legible, though, I think.
So,
What I propose to do now...
Before we move on,
is,
can I stop you for a moment, just to be quite sure that I've got this right? I mean, you're saying, first of all, this is compulsory acquisition legislation.
Yes.
You're then saying in the context of that, it reflects the value of the right to the owner, not to the acquirer.
Yes.
And then the value of the right to the owner can't include any value attributable to the scheme and so on, the Point-Gord principle.
Yes.
And in this case, you're saying that because of the grant of the exclusive right to take the oil to Star, there is simply no value in anything left in the ownership of the of Bocardo.
Yes.
Is that right?
What I'm saying, fourthly, is that the scheme, one has to identify the scheme. The scheme in this case is the exploitation of the petroleum license in the specified area. That's the scheme. One takes out of the valuation equation any value attributable to the scheme. The scheme in this case is the exploitation of petroleum in Great Britain through licensing, or by petroleum license holders. That's the scheme for which no element of value for the purposes of assessing compensation, for the purposes of compulsory acquisition, is payable.
In your list of points, you don't actually address the wording of the particular statute as to how compensation is to be addressed, but you're going to be doing that, I take it.
And that, of course, is maybe the issue, and that is whether or not the wording of Section 8.2, fair and reasonable between a willing grantor and a willing grantee, actually rebuts what would otherwise be the presumption. I understand, and obviously that is the question. Before I deal with that, can I just, to some extent, set the background by asking your lordships to look at two fairly recent decisions in which some of your lordships have considered the approach to the construction of compensation provisions in the context of compulsory acquisition legislation. And for this purpose, the first case that I'd ask you to look at is in fact the Spirose case, Transport for London against Spirose, which you'll find in volume 8 at tab 96. And I take you to this in order to set the scene, if I may, for the interpretation of Section 8.2 as it now is, which I say this is our case, and the Court of Appeal agreed. It means that what one does is, nonetheless, in spite of those words, arrive at the value of the rights to the grantor and not the value of the rights to the grantee. In this case, the issue was how should a printing works with potential for residential development be valued for compensation purposes when it is compulsorily acquired under the London Underground Estate London Line Extension Order of 1997. The answer was with an additional value for that potential, with no effect on value upwards or downwards because of the scheme. And if I can take to some of the passages, first of all, Lord Scott, paragraph 2.
Before you read out large chunks, it would help me at any rate to know exactly what you're going to get out of this.
What I'm going to get out of this is that the approach of the courts to the construction of a compensation provision in a compulsory acquisition legislation is that the presumption is that compensation is to be assessed on the basis of value to owner rather than value to acquire.
And this is a case which Section 5 of the Land Compensation Act applied to.
Yes,
is it?
it's true.
Can we just look at that? I mean, some of us are not as familiar as that as perhaps others.
My Lord, yes, we
What if you could just refer me to where it is in the bundles, that would be sufficient.
Well, it seems to be set out in paragraph 76 of this judgment, according to the footnote on page 1.
Okay, well, I'll set it up.
Yes, it is. Yes.
Thank you very much.
And it's Rule 2. Yeah?
that's rule 2. There are the 5 rules, in fact. But,
Do we need to see the others, or is Rule 2 good enough for present purposes?
It could well be. The language you'll see is not dissimilar to the language that we have here. the amount which the land, if sold in the open market by a willing seller, might be expected to realise.
I think going back to Lord Clark's point, it probably would help
Yeah.
to see the rule in context, because it does say subject to the hereinafter.
Well, it's volume 1, tab 8, I think, the whole act.
Yes, page 3. Rule 2. Rule 1, no allowance shall be made on account of the acquisition being compulsory. This is the one of the objects of this provision was to deprive the landowner of the 10% uplift, which I'll come to in a moment. Rule 2 is the basic valuation principle, that the value of land shall be taken to be the amount which the land, if sold in the open market by a willing seller, might be expected to realise.
And the hereinafter bit?
3, the special suitability or adaptability of the land for any purpose shall not be taken into account if that purpose is a purpose to which it could be applied only in pursuance of statutory powers, of which there's no market apart from the requirements of any authority possessing compulsory purchase powers.
And would that be very clearly and directly relevant if that had applied in our context?
Yes, it would, but nonetheless,
We don't mind the fact that it's not there, do we?
no,
I see.
that's the point, Gordon. But that as I'll take your lordship to your lordship's speech in Waters, but that is the approach that has been adopted by the courts for some time. Rule 3 by itself does not conclude the matter, because the approach of the courts to the interpretation of provisions of this kind, if it was just Rule 2, even if it was just Rule 2 without Rule 3, would be that the value would not include the value of the land to the acquirer if the only value that we're talking about is value which is attributable to the scheme. That's the approach which the courts have adopted. And there has been an approach by the courts to restrict the interpretation of Rule 3, which we're looking at now. But nonetheless, at the same time, there is, if you like, an overarching principle of interpretation of compensation provisions, a principle established in the 19th century, which excludes from the valuation any value that the land has which is solely attributable to the statutory scheme. But there it is. There are the 5 rules. Maybe I should call them 6, but 5 rules. Now, with that, may I just then take your lordships back to Transport for London. I'm taking you, and I'll obviously try not just to simply read these paragraphs. Some of your lordships, maybe all of your lordships, will be very familiar with them. But I rely upon and ask you to look at paragraph 2 of the speech of Lord Scott. Compulsory purchase, creature of statute, compensation to be paid to the expropriated owner is likewise provided for by statute. Current statute is the 1961 Act. Rule 2 reenacts the principle, but that had been established of the Acquisition of Land, Assessment of Compensation Act 1919, but that had been established earlier by judicial decisions interpreting and applying provisions in the Land Clauses Consolidation Act 1845, that compensation was to be assessed on the basis of the value of the land to its expropriated owner, not on the basis of its value to the acquiring authority, and then Rule 2 is in fact set out there. And as you can see, the language of Rule 2, putting to one side for the moment Rule 3, is not materially different to the language that we find in Section 8, subsection 2. And when we come to look at the Land Clauses Consolidation Act 1845, you will see that compensation was to be paid to the landowner for the value of the land. And that was no more than what was said. It was simply the value of the land.
Sorry, where is that provision of the 84?
I'm going to come to that, but perhaps if you'd like to look at it. No,
It's tab 7, but I'm not sure which section it is.
it's 63.
62. Tab 762.
63,
It's volume
I
1,
think it's
and
yeah.
it's tab 7, and it's section 63.
63.
Now, this is an 1845 statute, and as we will see, it's been the subject of a number of judicial decisions, and by the time, let us take 1923, by the time we get to 1923, it had been clearly established in the cases that value here simply means value to owner, excluding any value which is entirely attributable to the scheme. The language here is simply that regard shall be had for the purposes of estimating the purchase money or compensation to be paid by the promoters of the undertaking, now, not only to the value of the land, but also to the damage.
Is that an interpretation then of the expression value?
Yes.
Does it matter that Section 8, subsection 2, if I'm right, doesn't use the word value?
No, in my submission it doesn't. But I'll have to
You'll have to come
make
on
good
and explain that, yes.
Yeah. But it will become apparent as I take your lordships through these two House of Lords decisions. One is Sparrows, and the other one, of course, is Waters. But if one likes, one could approach it this way. Value, what does value mean? Well, it must mean open market value. That's what the court say. It must mean open market value. What is open market value? Open market value is what's fair and reasonable to be paid as between a willing seller and a willing buyer.
Well, you always have to know what it is that you're valuing.
Yes.
I mean, that's the crucial point, isn't
Yes. But in this case, the reference here is to land. In this case, we're valuing rights, the case before your lordships, we're valuing rights over land rather than the purchase of land.
Yeah.
But once one's identified what it is one's purchasing, whether or not it's land or rights over land, and that is an important distinction, which I hope to make good the proposition. It's an important distinction when one looks at the cases. Once one's established what one is acquiring, let's assume for the moment it is simply a freehold estate in land. Then what is the value of that freehold estate in land? It is surely nothing other than the open market value of that land. What is the open market value of that land? It's what is fair and reasonable for a willing buyer and a willing seller to agree as a price. We're not getting too far away from the words of Section 8.2. And so stopping there, value would ordinarily include, therefore, the value that the land might have. We've called it ransom value, we've called it key value, because it opens up the possibility of developing adjoining land, or because it has a potential for future development itself.
Or because it's particularly desired by a particular purchaser.
Yes. And so ordinarily, just if one looks at the word value, without more, one would have thought that value would have included the key or ransom value or the particular desirability that it might have for a particular purchaser in it. And therefore the price that would have to be paid might well indeed reflect the value that the acquirer of the land...
After all, that's the only real value in the key, isn't it?
Yes. In this case, it is, yes.
Or in any of the key value cases.
Yes,
It's all about what the key can open.
yes.
But I mean, the principle that you compensate on the basis of the value that the owner loses rather than what the acquirer gains, I mean, doesn't really mean very much in itself, does it? Because what the owner loses is what the acquirer gains, or vice
Yes,
versa.
but that's not the way that your lordships have... Or the
No,
House of
no, I
Lords has looked at it.
appreciate there is a gloss then put on it
Yes.
in the compulsory purchase
Yes.
context.
Yes,
I mean, this whole business of ignoring why the purchaser wants it is a gloss.
yes, it is. But it's a well-established gloss, and it was attacked in Waters and the Welsh Development Agency. Lord Scott, as you will all know, Lord Scott wasn't very happy about the gloss. He thought it was time to dump the gloss and just look at the words that one finds in the particular statute, which gives rise to the compulsory power of acquisition. But the rest of the House of Lords said no. There is the well-established gloss, Point Gord sometimes referred to as. It's been there since the 19th century, and now is not the time, it's too late, to abandon it. And the point that I am making is that when one looks at section 8, subsection 2, the words that are used there are not, if you like, sufficient to displace the gloss. That's essentially our case, and that is the case that the Court of Appeal accepted, and before the Court of Appeal, as I'll explain, but it's clear, Mr. Justice Peter Gibson accepted. And this is not a and this is a gloss, which again you'll see from the cases. This is a gloss, not necessarily the word I'd like to use, but it has been used. This is the gloss which has existed, so far as the courts are concerned, from the 19th century, and existed, therefore, at the time of the 1923 Act and the 1934 Act. Provides, if you like, something of the historical context, the legal background, to those two pieces of legislation which we're really concerned with.
And Section 8.2 had an identical predecessor as Section 9 did it of the 1923 Act?
Yes. Section 8.2 was reproduced in Section 9.2 of the 1923 Act.
So I mean, it dates back to 923.
It does. Yes. Just going back again, if I may, to Transport for London, I've taken you to paragraph 2. Lord Walker dealt with the statutory background in paragraphs 11 and 12. And 11 and 12 are important to the point that I am endeavouring to make. He said this in 11. In this appeal, there's been... I don't propose to read every paragraph.
This is Lord Walker.
This is Lord Walker. In this appeal, there's been a good deal of debate about what the point Gord principle is and whether it's relevant to the determination of the appeal. In my opinion, it's an imprecise principle in the nature of a rebuttable presumption adopted by the court in the interpretation of statutes concerned with compensation for the compulsory acquisition of land. It can be stated at several different levels of generality. I propose to take your lordships to Waters. It's only if the principle is stated at a fairly high level of generality that the court approaches the statute expecting Parliament to intend compensation to be assessed on a no-scheme basis. That's the general principle, that it has much to do with this case. The principle is essentially concerned with statutory construction. It's not concerned with the meaning of a particular word or phrase which has appeared in a succession of statutes dealing with the same subject matter. Therefore, if one has in mind the approach of the courts to the construction of this is not simply an approach to the meaning of the word value in section 63 of the 1845 Act, but with the general attitude and expectation with which the court should approach a statute dealing with compensation for the compulsory acquisition of land. Interesting to note that Bennion mentions Point Gord once only as an illustration of the following observation: where an area of law is of long standing and is made up of enactments, some with a long history, finding the legal meaning may be especially difficult to ascertain, here certain special interpretive conventions may have grown up. For example, such conventions have arisen in the compulsory purchase of land. One of these is known as the no scheme rule, or Point Gord rule, as stated by Lord McDermott. It's well settled that, this is a 1915 statement, by the way, Privy Council case, I think. It's well settled that compensation for a compulsory acquisition of land cannot include an increase in value, which is entirely due to the scheme underlying the acquisition. This rule may operate to influence the legal meaning of a relevant enactment. I then would ask your lordships to look at some stage at paragraphs 14, 15, and 16. It may be that I should, actually, if I may, just take you, before we break, to, maybe I should just very, very quickly take to those. Paragraph 14, last sentence in paragraph 14. Section 63 of the 1845 Act used the simple expression value as the statutory measure of compensation for land taken. This afternoon, I will take your lordships, if I may, to what Lord Nichols said of the single expression value and how he analysed it in Waters, because it is, in my submission, helpful for the purpose of this appeal. Paragraph 15, judicial exposition of this simple expression in an age which tended to set a higher value on private property rights than on communal needs, favoured the landowner by building in a premium because the purchase was compulsory, and reinforced this by what Lord Justice Scott in Horn and Sunderland Corporation, Lord Justice Scott was an acknowledged, as he goes on to say, acknowledged expert in this field, referred to as the old sympathetic hypothesis of the unwilling seller and the willing buyer, which underlay judicial interpretation of the Act of 1845. Lord Justice Scott was in a position to speak with authority as he chaired a committee which reviewed the law and led to the Acquisition of Land Assessment and Compensation Act 1919. The main purpose of that act was, as he said, to mitigate the evil of excessive compensation, which had grown up out of the theory of the unwilling seller and willing buyer, evolved by the courts. This was, in fact, the 10% uplift, which, in fact, receives, in this case, statutory, in the case we're concerned with, statutory endorsement. The 1919 Act achieved this purpose by 6 rules. These now appear in exactly the same language in Section 5. Judicial interpretation was not, however, wholly predisposed in favour of landowners. Indeed, the most important element of judicial exposition during the half-century before the 1919 Act, and therefore the half-century before the 1923 Act, was the development of the principle which Lord Nichols in Waters explained as follows. Well, I'm going to take you to Lord Nichols, but perhaps while we've got it here. When granting a power to acquire land compulsorily for a particular purpose, Parliament cannot have intended thereby to increase the value of the subject land. Parliament cannot have intended that the acquiring authority should pay as compensation a larger amount than the owner could reasonably have obtained for his land in the absence of the power. Stopping there, one asks oneself if I'm right in my identification of the scheme, or Justice Aiken's identification of the scheme. What could Bocardo reasonably have obtained for the land from anybody else? For the same reason, there should always be disregarded the special want of an acquiring authority for a particular site, which arises from the authority having been authorised to acquire it. This approach is encapsulated in the time-hallowed, pithy, if imprecise phrase that value in this context means value to the owner, not value to the purchaser. In Stebbing, the Graveyards case, Chief Justice Cockburn said, when Parliament gives compulsory powers and provides that compensation shall be made to the person from whom property is taken for the loss that he sustains, it's intended that he should be compensated the extent of his loss and that his value should be tested by what was the value of the thing to him, not by what will be its value to the persons acquiring it.
Can we just bear that phrase in mind and contemplate the position in the 1923 Act? Because there are various rights that can be or could be acquired under that, including a right to work minerals. In other words, you find coal down there, which is not really workable except, I think, it's Section 1, because of they're in small parcels and so on and so forth. Somebody's got the means to actually exploit them.
Yes.
Acquires the right to do so, and there's a compensation provision in what was Section 9, subsection 2.
Yes.
Now, how would you apply what's said there? He would get full compensation for the value of the coal that's extracted, would he? Because that's something that is being taken away from his ground and has a value. So to that extent, when you talk about willing seller and willing buyer, you're entitled to look to the value of what it is that is being taken away and assume it has a value in the open market.
Yes, of course you are, because there's a market for it. It's like the compulsory acquisition of a house. If an acquiring authority wants to acquire a house, it's got to pay the market value for the house. In those cases, you're acquiring an asset, the house, which has a value in the market. In relation to the 1923 Act, Your Lordship is quite right. There are two distinct rights which are made available under the 1923 Act and under the 1966 Act. One is the right to work the minerals. In other words, to acquire, if you like, ownership of minerals which you don't own. The other is the right, the ancillary right, and that is the ancillary right to use land in order to work minerals which you already own.
Yes.
Those are the two distinct rights, and they are different. This is a case where had we used the statutory route, we would have applied for an ancillary right. We wouldn't have applied, obviously, for the right to work the minerals. But in the former case, when you are seeking a right to work the minerals, in other words, to acquire ownership of them, because you don't own them, you want to own them so that you can work them and sell them off, you're actually acquiring an asset, and the asset will have a value in the no-scheme world, to use that terminology, will have a value in the real world. Coal under the ground will have a value, not just to the acquirer, but to the statutory acquirer, if you put it that way, but to other coal companies. Markham, that you've been taken to, is a completely different case to the case that we're concerned with, had we used the legislative route. In Markham, what the coal company was seeking was not the right to access the mineral coal which it owned, it was seeking the right to own the mineral. Now, that mineral, coal, has a market value, just like a house, to others other than the acquirer. And in those circumstances, the loss to the landowner, the coal owner, is the market value of the coal, because there's a market for it, and the market goes further than the statutory acquirer. So and this may then also explain the language. I know that Lord Clark thinks, well, it's just compensation, and there's no significance in the difference in the use of the word compensation and consideration, but there is, it's not the most important of the points that I'm attempting to make, but there is a difference. You pay consideration for an asset, you will pay consideration for an asset which has value, but in my submission you would pay compensation for the right to go over someone's land to exploit an asset which you already own.
You say that those words are carefully chosen because there are some transactions or some aspects of the right that's being acquired for which or to which the word consideration is quite appropriate.
Yes.
And there are others where compensation would be the better way of expressing
Yes.
it. But it's all built into the same formula.
Yes, but my Lord, when we come to look at the Australian Production Act 1934, you'll find that the only word used there is compensation. Now, whether or not that in my submission has some significance, it's not the be-all and end-all, but it does have some significance. But the Lordship is right. There is an important distinction to be made between the case where the acquirer is seeking to acquire an asset, such as coal or brick earth in one case, and simply acquiring an ancillary right.
Well, should we stop there now, due to the time, and come back to this discussion at 2 o'clock?
Okay.
Thank you very much.